What exactly is the crime of permitting child abuse by injury in Wagoner? Permitting child abuse by injury is one of the most serious crimes involving children under Oklahoma law. Many people mistakenly believe a person can only be charged with child abuse if they personally injured a child. However, Oklahoma law also criminalizes situations where a parent, guardian, or caretaker knowingly allows abuse to occur or fails to protect a child from abuse inflicted by someone else. Permitting child abuse is different than direct child abuse. Direct child abuse generally involves personally injuring, torturing, maiming, or otherwise harming a child. Permitting child abuse, on the other hand, focuses on the conduct of a person who allows the abuse to happen. Under Oklahoma law, child abuse includes not only actual harm to a child, but also the failure to protect a child from real or threatened harm to the child's health, safety, or welfare. The law is designed to hold accountable those individuals responsible for a child's well-being who knowingly permit abuse to continue. For example, if one parent knows another adult is physically abusing a child and does nothing to stop it, report it, or remove the child from danger, prosecutors may attempt to file permitting child abuse charges against the non-abusing parent. What must the prosecutor prove? To obtain a conviction, the state must prove specific elements beyond a reasonable doubt. Generally, prosecutors must establish that the defendant was a person responsible for the child's health, safety, or welfare, and knowingly or willfully permitted abuse to occur. Oklahoma's jury instructions require proof that the accused allowed or permitted injury, torture, maiming, or other abusive conduct toward a child. The prosecution cannot simply show that abuse occurred. They must also establish that the defendant had the required knowledge and responsibility for the child's welfare. Because knowledge is often disputed, these cases frequently involve extensive factual investigations and witness testimony. Who can be charged? The law most commonly applies to parents, step-parents, guardians, babysitters, caregivers, and individuals responsible for supervising children. In many cases, prosecutors focus on whether the accused had authority over the child and whether they knew the child was at risk. Oklahoma law specifically defines permit as authorizing or allowing care of a child by someone the responsible person knew or reasonably should have known would place the child at risk of abuse. What types of injuries can lead to charges? The term injury is broader than many people realize. Prosecutors may allege physical injuries such as bruises, burns, fractures, or other bodily harm. However, Oklahoma's child abuse statutes also encompass certain mental and emotional injuries when they are non-accidental and affect the child's health, safety, or welfare. As a result, these cases often involve medical records, photographs, expert testimony, DHS investigations, and forensic interviews. Is permitting child abuse by injury a felony? Yes. Permitting child abuse by injury is generally prosecuted as a felony offense in Oklahoma. Depending upon the facts of the case, a conviction may expose a defendant to extremely severe penalties, including substantial incarceration. Oklahoma's child abuse statutes provide for significant punishment because the state views crimes involving the abuse of children as among the most serious criminal offenses. In addition to criminal penalties, a conviction can affect child custody rights, visitation rights, employment opportunities, professional licenses, firearm rights, and future interactions with the court system. DHS investigations often accompany criminal charges. Many permitting child abuse cases begin with an investigation by the Oklahoma Department of Human Services. A criminal prosecution may occur at the same time as a juvenile-deprived proceeding, emergency custody action, or termination of parental rights case. Because statements made to DHS investigators may later be used in criminal court, individuals accused of permitting child abuse should be extremely cautious about speaking with investigators before consulting legal counsel. Defenses may exist. Every permitting child abuse case depends heavily on the facts. Common defense issues often include whether the defendant actually knew abuse was occurring, whether the injuries were accidental, whether the defendant had legal responsibility for the child, and whether the prosecution can prove the required intent beyond a reasonable doubt. In many cases, The defense focuses on challenging the state's claim that the accused knowingly allowed the abuse to occur. Medical evidence, witness testimony, timelines, and expert opinions often become critical in determining whether the prosecution can meet its burden of proof. Wagoner, criminal defense lawyers. Permitting child abuse by injury is a felony accusation that can have life-changing consequences. These cases are frequently investigated by law enforcement, DHS, medical professionals, and prosecutors simultaneously. The allegations often involve emotional testimony, complex factual disputes, and significant potential penalties. For a free consultation with a criminal defense attorney at Kania Law, Wagoner attorneys, call 918-283-7394.